Hi, and welcome to the CRIISP Growth Labs interview series, where we bring you expert insights and guidance to help you achieve your growth objectives. I'm your host, Rhythm Gupta, and I'm here today with a very special guest, Alex Solo, the co founder at Sprintlaw, a new type of law firm that is revolutionizing the legal industry. Today, our topic of discussion is streamlining legal processes for successful fundraising and investment. Welcome, Alex. It's great to have you for this interview.
Great to be here.
Amazing. Now, Alex, could you start by telling us a bit more about Sprintlaw and how it is actually different from the traditional law firms?
For sure. So Sprintlaw is both a law firm for startup companies, and also we're a startup ourselves. So we've been around for about 5-6 years. The sort of idea for the business was realizing that the way that law was traditionally practiced was really inefficient. Lawyers, were not using a lot of technology, a lot of systemization, a lot of process, meaning that legal services were not accessible for these sort of smaller organizations, with often complex legal needs, but they couldn't sort of afford that complex advice. So our idea was, can we design a law firm model that uses technology and innovative thinking to really bring down the cost of legal services and be able to provide those higher quality services to small organizations? So that's kind of what we're founded on, if that makes sense.
Amazing. That sounds very impressive. Now, when it comes to preparing for an investment, what would you say are the key legal considerations that small business owners and entrepreneurs should actually keep in mind?
For sure. I think, when you start a business, legals are not necessarily the most exciting and fun thing, at the front of your mind. You're often thinking about, how am I going to get customers? How am I going to grow? If you speak to a lawyer early on in your business, they'll tell you all of the different sorts of legal risks you need to manage. They'll tell you about contracts that you need, trademarks you need registered, company setup, and organization things you need to do. In reality, very few companies actually get the legal things done that they need to in their sort of early days. So capital raising is both a time to prepare some important legal documents to receive the capital, but also a time to do a little bit of housekeeping and clean up and actually get the backlog of legal things you should have considered really early on cleaned up before you go out and speak to investors. So those are probably the two categories of things to think about when it comes to legals. One is, what are the things I need to do just to get cleaned up and ready for investment? And then, now that I'm going out to investment, what are the legal documents or other considerations I might need to cover to sort of receive that investment?
That completely makes sense, Alex. Now, can you explain the different type of raises we have, such as straight equity, convertible notes, and safe notes? And if you could also shed some light on the legal implications that are associated with each different type of raise.
For sure. So yeah, when a startup's going out to raise capital, one of the most common things you're going to be doing is raising some form of equity capital. You may, of course, a more traditional way to raise investment is through a loan, but typically for startup companies that are trying to grow fairly quickly, it may not be that they can obtain a loan easily. They may not have existed long enough to obtain one, and they may not be able to make repayments in the short term required for a loan. So oftentimes you're going out for equity, and there's a third type of investment other than equity and loans called sort of convertibles, which sits somewhere in between a loan and equity. And so we've got the convertible note and the safe note as those sort of two types. So I'll just quickly cover those categories. So with the straight equity, what you're doing as a startup is you're essentially selling a portion of your company to the investors. So they're going to own a piece of the company. So they will invest X dollars in the business, and they'll get what percentage Y ownership in the company. So for example, you might raise $1 million, and maybe that's for 20% of your company, implying that your company's worth a $5 million valuation. So you receive $1 million, the investor has sort of 20% stake in the company. Then the idea for the investor is that, well, they won't necessarily get repaid in the same way that they would through a loan, but over time, they're hoping that the value of your company will go up from 5 million to maybe 10 million, 20 million. And either you'll start generating profits and they'll be entitled to 20% of those profits, or maybe you will sell the business one day or have some other exit event and they'll make a return on their investment. So if they bought in at 5 million, with their 20%, and you become worth 10 million, they will have doubled their investment. So that's typically how the straight equity works. And when you're negotiating a raise for straight equity, you're often talking about what am I going to raise, what quantum, what's the valuation of the overall company, and ultimately what percentage am I giving away. The other forms of investment, we've got the convertible and the safe note. These are very commonly used by early stage companies as a way of not quite valuing the company yet. The company may be very, very early on. It may be not clear actually what this thing's worth. If it's just an idea, it hasn't generated revenue yet. The founders have big ideas. It may be that they don't want to put a valuation on the company. So, but they still might need investment to get to the point where they can actually go and raise that equity and put the valuation on the company. So what you can do with a convertible note or a safe note is you can offer the investors essentially like an early bird discount on the equity round. So you would specify, let's say, a 10% discount in a convertible note or a 15% discount. And what that means is an investor will invest a certain amount of money in exchange for this discount. And while they don't yet know what percentage that they're getting in the organization, the idea is when later on you do that capital raise for straight equity, the investor will get a 15% discount or 10% discount on the price per share paid by the incoming equity investors. So it's a way of doing an equity round before you're quite ready. Often it's referred to as a bridging round when you use these convertible notes or safe notes. So that's kind of how that works, like the early bird discount to the equity round. And the difference between a convertible note and a safe note is subtle, but they're fairly similar documents, which basically set out a discount amount. A convertible note also often has an interest component. So if you take a long time to raise, the discount might increase over time, whereas the safe note's usually just a flat discount. So they're a very common tool used by early stage companies for capital raising. The final category I mentioned are, of course, the loans. And most people will be familiar with how a loan works. There's usually an amount of money that you're receiving from an investor. They don't necessarily have an ownership stake in your business, whether now or in the future, but they're entitled to an interest rate and a repayment. So for example, you might take a loan for $100,000, 10% interest. Depending on how it's all calculated, you're repaying $110,000 over some period of time. So that gives you a little bit of a sense of the different types of raises. And most commonly we see for startup companies, as I mentioned, either the straight equity raise or in their early stages, these use of convertible or safe notes.
Amazing. Thank you for explaining that, Alex. That's very valuable information. I'm sure our viewers appreciate that. Now, moving on, can you now shed light on what are the essential legal documents that entrepreneurs need to prepare when they're raising capital? And it would be great if you could also share with us the purpose of each document.
Absolutely. So to some extent, the documents that you use will depend on what sort of raise that you're doing. I just covered the straight equity, the convertibles, and the loans. The area of most complexity, and probably what I'll spend a little bit more time talking about, are what you do for the straight equity and the convertible notes and what the different documents are for that. Of course, if you do a loan raise, it's a fairly simple loan agreement. A single document is often signed covering the terms of the loan, potentially two if there's some form of security. But I won't spend too much time on that, as that stuff's relatively straightforward. If you're raising equity or a convertible round, typically you would begin with a document called a term sheet, which you would use as a tool for discussing with investors the terms of your investment. So there's different ways this plays out. Oftentimes founders will prepare a term sheet. And so a term sheet is a short, usually 1 to 5 page document. It's actually not a binding legal document. It's almost like an informal summary of what the legal documents will say. But it's a good way of speaking to investors without presenting them with a big pack of confusing legal documents and saying, look, this is the sort of terms of investment that we're looking at doing. So you can have a term sheet for a convertible raise or a term sheet for an equity raise. Both are acceptable. The term sheet will just basically say we're raising this much money at this valuation, or if it's convertible, at this discount rate, with this time frame. As an investor, you will be entitled to XYZ rights. Here are the founders, and so on. So a kind of key summary of the key terms of the investment. Often founders will prepare a standard one, go around, meet with investors, present them a term sheet, and get people signed up, and that's how they'll run around. That said, if you're dealing with more larger institutional investors, It may be that it happens the other way around. You'll pitch your business to them, tell them why you are going to make a return on their investment, tell them a little bit about how much you're raising, and then it may be that if it's a venture capital firm, for example, they present the term sheet to you, but it's a similar document covering the terms of their investment, what the valuation is, and explaining how the timeline works. It is better often as founders to control the document. If someone else is presenting you with an offer, it'll often benefit them more so than it benefits you. But it just depends on how the process sort of plays out. So the term sheet's the beginning. That gets negotiated, discussed. Eventually, it gets signed. Now, the signatures on the term sheet are not usually binding, except maybe with a confidentiality element. The rest of them are what we call in legal terms an agreement to agree. They say, here are the proposed terms of investment, and we're going to now do the big, long, formal legal documents and to finalize this deal. It's possible after a term sheet signed for the investors to pull out or for you to pull out. It is relatively common, though, for things to proceed. So the term sheet, while not legally binding, is an important, very, very important first step in the process of a capital raise. Once the term sheet's signed, from there, it depends on whether you're doing the convertible safe notes or the equity raise. If it's a convertible or a safe note, there is a document called a convertible note or a safe note agreement. Those are 20-page agreements. They go through all the legal bits and pieces in terms of how things work and those sorts of things. They'll get negotiated and signed, and then the money will come in after that. So they're relatively straightforward. And that's one big reason a lot of early stage companies go with the convertible note term sheet approach. Convertible note safe note approach, because it's a very efficient way to raise. If you're raising an equity round, there are a few more documents. There'll be a document called a shareholders agreement. There'll be a document called a subscription agreement, and a document called a constitution that you may already have. The subscription agreement, I'll start with that one, is like the investment agreement. It says the investor will put in X dollars for Y% of the company, and a few other bits and pieces around how and when the money flows in. So it's the kind of document that the money flows under. The shareholders agreement is a separate document, and that document is sort of covers what happens after they are essentially a co-owner or investor of the company. It governs their rights as usually a minority shareholder, what rights they have to control the company as a part owner, and what rights the founders may have to do things without their approval. So you've got the subscription agreement and you've got the shareholders agreement. One is for the money flowing in, the other governs the rules after the money's flown in. And then there's this underlying document called a constitution, which kind of governs how the board runs and how decisions are made and how meetings are held and those sorts of procedural matters. So it is a bit more intensive when you do the equity round because at that point you are actually giving a stake or ownership in your company to some new people. And so the legal documents become very important to govern the terms of those relationships. And that's sort of how it works. Beyond those documents, there are other bits and pieces that might happen as part of an equity round. As I mentioned earlier, there's some housekeeping that often happens where intellectual property agreements will be signed by founders. Founders will enter into employment agreements and so on. So it just depends on how the round plays out. But those are sort of the main documents, if that makes sense. Yeah.
Absolutely. Well, thank you for informing us about that. Now, investors often have the specific terms that they request during the investment process. So could you actually shed some light on common terms and clauses that investors may ask for, and how entrepreneurs can actually approach negotiating these terms?
Absolutely. So yeah, I mentioned earlier that particularly in those equity fundraisers where you're giving a portion of ownership in the company to one of your investors, in addition to the money that they're putting in, now that they're becoming a co-owner, they may want certain controls or rights to control the way the organization is run. These terms are set out in that shareholders agreement document I mentioned earlier, and occasionally in that subscription agreement document, and they're usually summarized in the term sheet at the beginning. So it's an important part of the process to work out, okay, I'm going to take this money, but what control am I actually going to give up to these investors? And what am I going to be comfortable with them sort of having veto rights over? So the sorts of things investors might ask for are things like board appointment rights. They may want a seat on the board of directors. That gives them an ability to have some oversight over how the company's operating and how decisions are made. They may want things like founder vesting clauses. So founder vesting clauses are clauses that say, well, look, we the investors are giving you an amount of money in the business, And we'll take a whatever minority stake in the business. But if one of the founders who currently has a bigger stake than us leaves after 2 months, 3 months, just after our money comes in, we're not going to want them to maintain their existing equity share just because they were there before our investment came in. So they may require founders to stick around in the business for a certain amount of time, or require that founders give up some of their equity. There are restraints, again, if founders leave, to stop them from taking the IP of the company and setting up a competitor organization. There's often anti-dilution clauses. So this means that if an investor, there's a future fundraising round and the value of the company has gone down, or even if the value goes up, if the company wants to let other investors come in, they must first offer this investor the right to invest and maintain their percentage holding. And in some circumstances, the valuation goes down. It might be that the founder has rights, which we call liquidation preferences, which essentially set out that their holding will go up. They invested on the basis that the value of the organization would go up. If it goes down, they want to be protected and make sure that they haven't invested at an overly high valuation. So these anti-dilution clauses are often terms that are asked for. And those are sorts of the main things. There are also access to information rights. They may want the right to get reports from about the company from time to time. They may want some promises that any materials that they've been provided prior to the investment are accurate and not misleading, and those sorts of things. But that gives you a little bit of a sense of how investors think about terms in terms of protecting their investment. Now, I should say a lot of these sit in these shareholder agreements, subscription agreements. If you're doing the convertible round or the safe round, oftentimes you don't negotiate all of this stuff as part of the round. Another reason why a lot of early stage companies use the safe note or the convertible note. It's just an early bird discount to the eventual equity round. And those safe note or convertible note documents say, hey, look, we will not negotiate all of these control terms with you right now. What we'll do is at the time of closing the equity investment, those terms will be negotiated with investors coming in then. And we, the early investors, are going to have the same rights as the future, usually larger investors that come into the equity round. So, so these terms often sit more just in the straight equity raise rather than those convertible raises.
Mm-hmm. Understandable. Now, as a parting question, Alex, can you tell us, in your experience, what are some of the common legal challenges or mistakes that entrepreneurs face when they are raising capital, and how can these mistakes be avoided?
Absolutely. So, I mean, we've helped, a lot of companies raise investment. We've seen a lot of situations where things have gone right and things have gone wrong. And I guess ourselves, Sprintlaw's raised at this point, I think 4 rounds of capital. So we've made some mistakes ourselves, despite being lawyers, and gotten some things right as well. I think first one is very important not to try and DIY some of these important investment documents. Some entrepreneurs, for some of their legal documents in the early days, don't want to sort of pay legal fees. And there's things like privacy policies or terms and conditions that you might be able to find templates online for. Those things are fine, but for these important documents that could cover hundreds of thousands or even millions of dollars, it's not the sort of thing you want to do yourself. And very often we see founders that have done, let's say, a seed round themselves, or a bridging round themselves, it comes to a Series A round, and they've accidentally given up much more equity than they should have by just using a template document that they didn't understand how it works. And that could be worth a lot of money. So you want to make sure you get professional help with these documents. And even though there are templates online, maybe you can use them as a guide for when you're preparing for negotiations. But before you sign at the dotted line, make sure you know what you're signing and there's no mistakes in there. A second is understanding these control terms and what control that you're giving up. Oftentimes, founders think a lot about valuation. So they'll think, oh, this investor that's coming in is going to give me a really high valuation for my business. My business is worth tons of money. They're really proud of that valuation. But the fine print might have these anti-dilution clauses that I mentioned earlier and a bunch of other T's and C's, if you will, that say, yeah, you're worth all this much. But if you guys don't grow beyond that amount, we're actually going to take most of your company. So it has strings attached. And sometimes, it may be more sensible to take a lower valuation on better control terms than a higher valuation where the investor has a whole bunch of protections, particularly if you're not sure that your organization can actually exceed the valuation of the investment. So that's another mistake we see. Founders thinking they've signed a great deal, but when they look at the T's and C's, it's actually not as good as they thought. The third one is leaving it all to the last minute. And I think that's certainly a thing that founders would often do. They're very busy and they underestimate the time required to get these documents right. I think it's worth, if you're going to be raising capital, setting aside some time early on to do the cleanup, to do the housekeeping, make sure you're ready to raise, and then make sure you leave enough time in the investment process to properly consider the terms of investment before you sign at the dotted line. So really think about it as something you should prepare early for.
Amazing. Well, thank you so much, Alex, for coming on for this interview and sharing your experience and insights on streamlining legal processes for successful fundraising and investment. Your guidance is undoubtedly very valuable to our audience. For anyone who would like to get in touch with the team at Sprintlaw, please see the details at the side of the screen and feel free to reach out to their team. And once again, Alex, thank you for joining me for this interview, and I wish you all the luck with your venture moving forward.
Thanks so much.
Thank you.